Hi. When analyzing questions concerning issues related to the Fourth Amendment, the courts break down the analysis with the following questions. Was the search or seizure conducted by a government entity? Did the search or seizure intrude upon an individual's privacy rights, privacy interests? Did the government have a warrant? If no warrant, did an exception to the warrant requirement apply? Was the search or seizure reasonable under the totality of the circumstances? Let's look at question 1. Was the search or seizure conducted by a government entity? The Fourth Amendment only restricts searches and seizures that are conducted by a government entity or a government agent acting for the government. Identifying a government entity is usually straightforward. Identifying an agent can be more difficult. The court will ask itself questions such as, did the government instigate the agent's search of the individual? To what degree did the government participate in the search? How much control did the government have over the search? And was the agent acting to protect its own business interests or those of the government? The Supreme Court's 2013 case, United States v. Keith, can be used as a way to show the differences between non-government entities acting as a government agent and another not acting as a government agent. Keith sought to suppress evidence collected from a search of his house. The result of a search for child pornography initially detected by AOL from Keith's AOL email account. AOL reported, as required by federal law, its findings to the National Center for Missing and Exploited Children, which then reported it to the police. The National Center for Missing and Exploited Children provides government investigative reports, which they generate after receiving tips from online services concerning child pornography. Keith argued that both AOL and the National Center were both not government agents. The court found that AOL was not a government agent because its search of emails was solely to protect and prevent pornography on its service. AOL was acting to protect its own business interests and not those of the government. The court did find that the National Center, after receiving notification from AOL and investigating further, was a government agent because statutory language describes the report programs of the National Center as a partnership between the National Center and government. So AOL was acting in its own business interests and not those of the government. And the National Center, as a partner with the government, was an agent of the government. Well, I hope this helps. I hope it explains a little. Have a good day.